Number one is get a graphics team and litigation consulting team involved early in the case. You don't have to do it when you file the complaint or when you respond, but early enough so that they can get a good grasp of the facts and help you develop a story as you go along. When you wait to the last minute, as in anything you wait to the last minute to do, things are rushed and it's not going to be as high quality as you want it to be or as it could be.
Works to be able to take a complex subject and reduce it to something interesting and understandable. You really need to test, and that's another thing that I guess I would encourage all litigators to do, is do more testing obviously at a minimum informally with your friends and spouses, but in particular with mock trials and getting the input of real jurors or real mock judges and collecting that input and that feedback in a useful way and turning it into actionable work in the courtroom, turning it into an actionable message that is delivered well in the courtroom.
That the best trial technicians can anticipate what the attorneys want, what they need, and they can go an entire trial without the jury probably even noticing, or the judge even noticing that they're sitting there. And I think that ability to blend in seamlessly to the team is key in terms of using an on-site trial technician.
When you're a practicing litigator, you need to be a master of all the facts. And when you're a master of all the facts, sometimes you get lost in those facts. And you need somebody to kind of pull back the zoom lens a little bit and take a look at what your case really needs. Use of technology is a must. If you can afford it, you must use it. If the court will allow you to use it, which almost universally they will, you must use technology. Otherwise, you look like you're not trying. During discovery, demand that the opposing side produce all the media that they have related to that could be relevant in any way. I think that litigation teams overlook this. It's something that we did not overlook in our litigations, and we used it as a large club against the opposing parties. And it was a club that, along with our expert witnesses, won the case for us.
Is you have to take into consideration the audience and really what your case is about. So if you have a pharmaceutical case that you have to describe this very technical process by which you're making a drug, then you are definitely going to need things like an animation or more of a high-tech presentation that you can explain explain to the jury the process so that they can visually see it as well as hear the explanation. And that can be accomplished using stills as in a board as well, but I think that you have to just use, it just depends on what exactly it is that you're trying to convey to the jury. And then
Nowadays, people are so in tune with media that if you don't present something to them that gives them that same feeling of the presentation they get from the news or what they see online on nice web pages, which they see all the time, people are going to tune out. A lot less people read nowadays than get their information visually through and auditorily from people talking and being backed up by graphics. And if you're not doing it, then you are living in the stone ages of typewriters and dictation, and it's not going to be effective. How did they do it back then? The same way cavemen made fire. You rub two sticks together and you get a result, but it's a lot harder.
also think that you have to take your courtroom into consideration. Some courtrooms are really small, some courtrooms are really big. Is the courtroom wired? Is the courtroom not wired? What's the judge's tolerance for technology? There are still judges out there that don't particularly care for the technology. So those are things that I would find out before.
I think the great litigators, and I've had a chance to work, I think, with many of the world's best, they leave themselves open to great ideas. They take in everything from everywhere they can get it. They're like sponges for great ideas and great thought. And then they do what feels right. They pick some of this, some of that, and they make the salad of litigation perfection, and they go forth and they try the case. Those are the great litigators in the country.